they've dismissed the emergency appeal. What this means, practically speaking, is that women in Idaho, even despite Idaho's very restrictive abortion laws, will be able to still get emergency abortions.
The Supreme Court kicks an abortion case back to the lower courts and releases multiple decisions on other cases ranging from social media to homelessness to the power of government agencies. Welcome to EWTN News In Depth. I'm Catherine Hadro. Several of the decisions have divided the court along ideological lines. These decisions will have profound implications on healthcare, free speech, religious freedom, and the power of government. The High Court released two major decisions on Friday, both split 6-3 along those ideological lines. In Grants Pass v. Johnson, the court ruled that cities can enforce bans on homeless people sleeping outside in public places. It found that such laws do not amount to cruel and unusual punishment, even in areas where shelter space is scarce. And Loper Bright Enterprises v. Raimondo, the court reversed decades of regulatory law, making it more difficult for federal agencies to issue mandates and regulations that aim at filling in the gaps of legislation passed by Congress. In Justice Roberts' opinion, he rejected the suggestion that agencies, rather than courts, are better suited to determine what ambiguities of federal law might mean. Justice Kagan sharply criticized the decision, saying that the court has given itself exclusive power over every open issue. One of the cases centered on abortion was inadvertently and briefly posted on the court's website one day prior to the official decision, which was released on Thursday. It is the second time in 2 years that a major Supreme Court abortion decision seems to have leaked before the official release. In this case, Idaho and Moyle versus the United States, neither pro-lifers nor pro-abortionists are claiming a win.
Unfortunately, even though this is good news, we know that that's now going to plod through the lower courts.
I was very disappointed that the court didn't at least keep the stay in place, because before they at least had stayed the decision.
Advocates on both sides of the abortion issue left disappointed after the Supreme Court once again leaves major questions unanswered in its decision. In a limited ruling, the Supreme Court ruled on Thursday that Idaho is required to perform emergency abortions under the Emergency Medical Treatment and Active Labor Act, also known as EMTALA. Originally passed in 1986, the federal law was created to prevent hospitals from dumping emergency room patients who could not afford treatment. In 2022, the Biden administration updated guidance on the law to include emergency abortions and sued Idaho over its pro-life law that limits that. In a 5-4 decision, the court punted the questions posed in the case back to the lower courts, and in a 6-3 vote, it removed its previous stay that prevented the EMTALA guidance from taking full effect in Idaho.
The case has been a bit of a moving target, both because the Idaho law has changed somewhat in the pendency of the litigation, and because the United States, in its arguments to the Supreme Court, made a lot of serious concessions.
This ruling does not impact similar pro-life laws in more than a dozen states and keeps Idaho's law mostly intact. Pro-abortion advocates saw it as a temporary victory, and pro-life advocates saw it as a setback. While HHS Secretary Javier Becerra praised the ruling, he emphasized that it does not change the fact that reproductive freedom is under attack. The Biden-Harris administration is committed to protecting access to emergency medical care for everyone in America and ensuring that women get the care they need. Idaho's Attorney General Raul Labrador promised to keep fighting the Biden administration's lawsuit.
I remain committed to protect unborn life and ensure women in Idaho receive necessary medical care. We feel good about where we sit today, and we look forward to the Ninth Circuit actually reading the tea leaves from the Supreme Court and understanding that the Biden administration's overreach needs to end.
And joining us now is Cristina Martinez Squiers, attorney at Sher Jaffe, to help us understand the implications of these Supreme Court cases. Cristina, thank you so much for joining us. There's been a flurry of important Supreme Court decisions. I want to address the EMTALA one first, concerning abortions in Idaho. What exactly did the Supreme Court decide here?
So it's very hard. It's a very hard opinion to digest because there is a lot of writing going on from amongst the different justices. But the headline is that the Idaho law is now stayed in terms of what the district court said was allowed to go into effect. So certain parts of it can't, to the extent that it conflicts with federal law and doesn't allow abortions in certain situations. And the court decided that they would wait to make a full merits decision later on. So that's the headline of what came out of that case.
What's your initial reaction to that decision?
I'm not surprised. I think the case did morph a lot from the time that the court accepted it, and the court accepted it in an emergency posture. And since the time the court decided to do that, from the time a decision would have come out, the law actually changed. It was amended by the Idaho legislature. The Idaho Supreme Court weighed in on what the law actually meant, and the government's position on what EMTALA meant also changed. So there were a lot of moving parts. So even though it seems bizarre that the court would have sent it back down after the extensive briefing, over 2 hours of oral argument, it's not surprising given how the contours of the case have changed over time.
On that point, Justices Jackson, Alito, Thomas, and Gorsuch all thought that the court should resolve the question of whether the federal law overrides Idaho's law. Here's what Justice Ketanji Brown Jackson had to say, quote, "While this court dawdles and the country waits, pregnant people experiencing emergency medical conditions remain in a precarious position. This court had a chance to bring clarity and certainty to this tragic situation, and we have squandered it." You know, Cristina, pro-life advocates are disappointed that abortions will continue in Idaho, obviously. But what is next for this case, and could the Supreme Court ultimately take this up again?
They absolutely could, and they will very soon, is my prediction. So I think what people forget is it's not just this case challenging EMTALA, but a very similar case has also already been petitioned to the Supreme Court on the behalf of the state of Texas, who actually sued the federal government over their law being in conflict with the federal law. And so that case, the court asked for Texas to file a response in just the next few weeks. And unlike the Idaho case, that one was fully briefed and finalized in the lower courts. So the Supreme Court won't have the same reason to reject it as it did with the Idaho case.
So just to kind of flesh that out a little bit more, this case, could it have bearing on other states as their pro-life laws also face legal challenges?
It could, to the extent that it's obvious that those laws conflict with federal law. So I think when people say this is just confined to Idaho, that's not quite true, because the question more is about when this federal interpretation of EMTALA conflicts with a state law, what does that mean and which one wins? And so that has a lot of ramifications for other states that have abortion restrictions, maybe not the same as Idaho's, but similar.
Really helpful clarity there. In other huge news, the Supreme Court upended the 40-year-old Chevron decision. Cristina, how significant is this?
Incredibly significant, and much more so in the short and long term, I think, than even any of the abortion cases it had this term. I mean, this precedent had been around, like you said, for decades. It had really given the federal agencies tremendous power to legislate, essentially, to do Congress's job. So this is definitely, I think, the biggest case of the term, people would probably say.
You know, speaking of this case, the Little Sisters of the Poor, they actually filed a friend of the court brief last year in support of the fishermen that were involved in this Chevron case that we're discussing. Cristina, can you explain what implications this case has for religious liberty and conscience rights?
It has tremendous implications for religious liberty and conscience rights, because as we've seen particularly the last two presidential terms, when a president comes into power, appoints people and to lead these agencies, they're using these agencies for very political ends. And so we've seen that with abortion. We've seen it with, the contraceptive mandate even a decade ago. We've now, the hot topic for that is transgender care. And so the heads of these agencies are using statutes to their political ends, interpreting them the way they want. And the court basically today really curtailed a lot of the agency's ability to do that and said, if you do this, we can overrule you because we're taking essentially a first review. We're not going to defer to how you're essentially twisting these statutes for political ends.
As we're talking about this case, and you mentioned just how significant this week's ruling is when it comes to overturning Chevron, can you just clearly define what that Chevron ruling is and practically means for our viewers?
Absolutely. So Chevron came about 40 years ago, and it was a rule that the Supreme Court announced that said when a statute was ambiguous, a statute that was passed by Congress, the agency in charge of implementing that statute, whatever their interpretation of that ambiguity was, would get tremendous deference from the court. So only unless it was very outrageous or something so unreasonable would the court overturn or have a different interpretation of the statute. And what the court said today basically was, we're not going to give that type of deference anymore. The court's job, the judicial role, is to interpret law. And so whatever the agency says, we're still going to take the first review without owing any deference to their interpretation of the law.
Thank you for that clarity. Okay, another big important case. The Supreme Court decided on Friday cities can enforce bans on homeless people sleeping outdoors, even in West Coast areas where shelter space is lacking. Can you break down this Supreme Court decision as well?
Absolutely. So I think it's important to note the restriction that was in place in this case was actually not just targeted towards homeless people. It was just a general ban on encampment in public spaces. And so that was part of the Supreme Court's analysis. The plaintiffs challenged it, saying that this was cruel and unusual punishment under the Eighth Amendment that targeted homeless people. And although it had a disproportionate effect on homeless people, the court essentially said, this is not cruel and unusual punishment. It's not targeted towards homeless people. It's just a ban across encampment in general. And the Eighth Amendment is not really about what conduct is criminal. It is about the types of punishments that are administered and to make sure that those are not cruel and unusual. And here, the challenge was really to the law, not about the punishment.
Cristina, we have just under a minute, but I want to ask you this question while we have you. The High Court dismissed another case earlier this month about the safety of mifepristone. So 2 high-profile cases that had limited rulings. Does this point to how the court handles the life issue after the Dobbs decision, in your opinion?
I think so. I think it's great that this Chevron case came out first before those cases will be addressed on the merits, because now we don't have the FDA's interpretations and HHS's interpretations standing in the way of the Supreme Court saying, what these agencies has done is completely out of line. And so I think it's phenomenal that we have this now open door for the court to look at these things in the first instance without having to get over the hurdle of what these agencies are doing for political purposes.
Cristina, thank you so much. Great to speak with you.
Thank you.